Very good evening to everyone, to one and all join with us for the session on understanding medico-legal complications in India. We have one of the eminent speakers from Tamil Nadu, Dr. A.L. Meenakshi Sundaram sir, Dean Government Medical College, Perambalur. He has been giving talks on latest all the updates in the legal implications with reference to the medical fraternity. I hope the sessions will be fruitful for all of you. Thank you. Doctor, over to you.
Thank you. At the outset, I thank for the wonderful opportunity given to me. Now, when I have decided to talk about medico-legal complications, it is very difficult to present everything in 45 minutes. So, first I will go to the overall implications, and I request the participants, try not to read the screen. Please listen to me. The screen will be full of letters for the simple reason the court's words should be reproduced in the same format. So I have reproduced the judgment format. So I will tell the points in that, but for legality, we have maintained the same wordings. So it will run to lengthier and lengthier sentences because the judiciary wants to pronounce the judgment according to the non-medical parlance. So it goes the lengthier pages. Sometimes the judgment goes to 100 and 150 pages. So don't try to read the lines. I will quote what are all the implications in that. So you follow me instead of the screen. So at the outset, as it is a legal session, I want to tell all of you, see, please, what I am saying is only an example, and don't try to take it as a legal consultancy. Whenever there is a problem, you please meet and consult a good lawyer. What I want to convey now, when a doctor witnesses the scenes like this, he will be active in that. He will be active in treating the patients. So the doctor is active in others' crisis. But whenever a legal notice is slapped on the face, the doctor tries to run away from the scene. So we have to know why it is happening. See, the legal notices against the doctors are steadily rising, and because the doctors are not aware of the legal issues and they concentrate only on medical education programs. So they have to learn the legal side also, but the best policy is to adapt. Prevention is better than cure. Why the doctors are afraid of these legal problems? Because they are having a social stigma of meeting police and lawyers, and the doctors are not aware of law of negligence, because law of negligence is not like an Indian penal code written in the book. We have to read the judgment and we have to derive. And the relying on textbooks by the lawyers and the judges create more problem because we are reading Western textbooks and practice on Indian population. So there is no definite law for each and every problem, and the judgment varies from judge to judge. And most of the time, the judge is a non-medical man, because it should be like that when decide about the medical negligence. So now I will give the court wordings. First of all, we should know who is negligent in medical negligence. The court feels the professionals should be treated in a different way, not like ordinary citizen, because there is no guarantee in the professional result. A lawyer cannot guarantee a successful judgment, and a doctor cannot guarantee a successful treatment. So the only assurance can be given by the professionals that he is possessed of the requisite skill in that branch of profession. So the court says, the Supreme Court said, three essential components of negligence. One, there should be a duty. That is, a doctor consults a patient, takes care of a patient. There should be a duty, and the doctor should have breached the duty. That should be the second derivative. Number three, because of that breach, there should be some damage. So only these three parameters should be there to prove a doctor is negligent. So in the Jacob Matthew case is widely quoted case, 2005. Till now it is valid. So I request all of you to go through the Jacob Matthew case, because it says a prudent man, what he does, it should be done by the doctor. Same way, a prudent man, what he should not do, it should not be done by the doctor. So the negligence becomes actionable only when there is an injury. So duty, breach, resulting damage. And here there is a peculiarity. They have mentioned there should be a gross damage. This gross damage is 304A. Routinely they say 304A. It is rash and negligent activity. So a doctor can be booked in criminal case only when there is a gross injury. But this word gross will be interpreted by only by the judges, and it is very difficult for us to interpret. So it differs from case to case. So to prosecute a medical professional for negligence under criminal law, the gross should be there. Again, the doctor is held negligent for two reasons. One, he was not possessed of the requisite skill which he professed to have possessed. If suppose I am professing that I am an anesthetist, I should possess the anesthesia degree. Or he did not exercise with reasonable competence in the given case, the skill which he did possess. So I have to have the degree, at the same time, I have to act accordingly with a reasonable skill. And again, what the court demands, it is a consolation factor for us. What the court demands only an average skill of an average doctor. They cannot say that a top ranked doctor's level could not be matched by the low ranked professional. It is not like that. So a normal doctor in that particular point of time, what average skill he exercises, we should exercise only that. So in the Jacob Matthew case, the court said that treating a doctor should be in a different way, because there is a marked tendency to look for a human act factor to blame for an untoward event. Routinely, when a patient dies, they break the hospital, they beat the doctor, because there is a tendency which is closely linked with the desire to punish. So even the court is aware of that. So the court itself mentions the inadequacies as a system, which the doctors say, the specific circumstances, human psychology, everything will blame the doctor, even though the doctor may be blameless. And the court said the human body is a complex machine which non-medical people could not understand. So in defense, all the doctors should use this word by the Supreme Court. The human body is a complex machine and its working cannot be interpreted by the non-medical man. So again, in the same Jacob Matthew case, the Supreme Court said negligence should, with a doctor, there should be some difference. Occupational negligence is different from professional negligence. A simple lack of care or error of judgment cannot be held as negligent. Again, it says the doctor should act only with a reasonable skill. And at the same time, the Supreme Court exercised a word of caution. After telling so many things, at the end it says, we may not be understood as holding that doctors can never be prosecuted for an offense. So it gives a word of caution. What the Supreme Court requires, it needs for some protection of the doctors from frivolous or unjust prosecutions. Same way, in another case, the Supreme Court case, where there is a bench with Suryakant and Justice Bopanna, they said, where the treatment is not successful or the patient dies during surgery, it cannot be automatically assumed that the medical professional was negligent. That is the thing. So to indicate negligence, there should be some material available on record. The onus falls on the shoulders of the complainant. Again, the negligence should be so glaring, then only the res ipsa loquitur, that is, things speak for itself, could be applicable and not based on perception. So I want to quote some guidelines on the medical negligence on consent, because I know mixed people will be attending on it. So I am taking only the common criteria. See, one doctor has obtained a consent in a blank consent form. So that was considered as negligent. Blank consent form. And the treatment was got signed by the patient and did not bear either the information by the patient or signature of the doctor. So I want to tell, consent form should be signed by both the parties, both patient and the doctor. So the court quoted the authority, the regulation 2007 of Medical Council and a book by Dr. Amit Kohli, Radiology Department. So the court mentioned the doctor cannot escape his liability for not taking proper care as per standard protocol. So he follows standard protocol. Getting a blank consent form is a negligence. Same way, the anesthesiologist without consent introduced a diclofenac suppository. So the patient felt it odd because the suppository is inserted in the rectum. So the doctor was sued. The same way, an anesthesiologist was held guilty for giving spinal for the patient who opted for general anesthesia. So consent is important. So in the consent cases, in one patient, the doctor has not taken a written consent. But the judge ruled the patient was all along conscious till anesthesia is induced. She knows that premedication is given and she was taken to the theater. Her relatives are also aware of that. So no doubt that there was an oral consent and the complaint dismissed, because now it is oral consent is not allowed. But the judge ruled like this, but it happened in 92 in Tamil Nadu. But now things are different. So oral consent and no doubt there is a oral consent and the complaint dismissed means the judge was an attractive judge like this. But I want to say so many judges will be like this. So we have to be very careful in the consenting. So case law and consent must be procedure specific. These are all the two authorities. Then consent needed for blood transfusion. Name of the anesthesiologist needs to be mentioned on the consent. Whatever I am saying, it is based on the court judgment. So in Mekulla foreign judge, there was a consent for general anesthesia, but the patient was given caudal for postoperative pain, but persistent numbness was there. So the patient sued, I have given consent for GA, but because of this caudal, I had a problem. But the judge is a good judge. So he ruled caudal is a part of anesthesia. So why should a separate consent not also be sought for an injection, for example, morphine to provide analgesia? Step by step consultation is not possible. Same way, he mentioned how long will it be before the court is invited to say that separate consent should be sought for separate steps in surgery. It is not possible. So again, I stress the judgment differs from judge to judge. So we cannot take all the judges for granted. Here, in one Texas case, consent was obtained for this wife's surgery, consent obtained from the husband. The wife appealed and he has lost the case, and again she has gone again for appeal to the highest court. There they ruled the husband was wrong and the doctor was wrong because there was no consent, that the patient's spouse was authorized to consent on her behalf. The husband and wife relationship does not in itself make one spouse the agent of the other. So this is a word of caution. Just by getting a consent from the wife, we cannot operate upon the husband. By getting a consent from the husband, we cannot operate on the wife. So the lessons to be learned: informed consent. What is informed consent? What to do in unconscious patient to protect the doctors in emergency situations. The court has given a state wording called implied consent. Implied consent means even without a consent, it is presumed that the patient has given consent. This implied consent is applicable only in emergency. This is for protecting the doctors, because in road traffic accidents and unconscious patients, without a consent, if the doctors are reluctant to operate, then there will be a problem. So the court has given for these patients a terminology called implied consent, but routinely we have to get informed consent. Here, this case everyone should read. This is by the Supreme Court of India, that is Samira Kohli versus Dr. Prabha Manchanda. This case is important because in this case, the patient was taken up for diagnostic laparoscopy. During that laparoscopy, they have made severe endometriosis for the patient. So they have done a laparotomy and they have removed the uterus and the ovaries. So it is hysterectomy with bilateral salpingo-oophorectomy. The patient is 44 years. Imagine the patient is 44 years and the patient claimed without my consent, because the patient was in GA for laparoscopy, and by taking the consent from the mother, they have operated upon the patient and removed the uterus. So the age of 44, unmarried patient. So she sued, I cannot enter into the marital life without my consent, it was removed. So the court said, yeah, this sort of a procedure should not be done, even though it is right. Even though it is right, without a consent, the doctor has operated upon the patient. So the doctor was punished. Punished in the sense, they demanded a compensation of 15 lakhs, but the court said the doctor has done it with a good intention, but there was a procedural flaw. So he has to forego his fees, and 25,000 should be awarded as compensation, and 5,000 should be awarded as a cost for the court proceedings. So in that, the judgment quoted adequate information to be furnished by the doctor to get a consent, and it should be a balanced judgment. That is, the doctor should disclose nature and procedure of the treatment, alternative treatment if any available, an outline of the substantial risks and the adverse consequences of refusing treatment. These adequate informations the doctor has to part with the patient. At the same time, the court warned there is no need to explain the remote or theoretical risks. But in Australia, we have to inform even the remote and the theoretical risks, like death in the perioperative period may be possible. We have to say. But Indian court said these sort of things need not be informed to the patient, which may frighten or confuse a patient and result in refusal of consent for the necessary treatment. So, with a good intention, the court has said like that. Same way, if the patient refuses, the doctor need not say the remote theoretical risks. A balance should be achieved. Again, it is only a balance. The consent given for the Samirapoli case, for laparoscopy, they have undergone laparotomy. Consent given only for a diagnostic procedure cannot be considered as a consent for therapeutic treatment. Same way, consent given for a specific treatment procedure will not be valid for conducting some other procedure. So the unauthorized additional surgery, see, routinely the doctor say, no, what I have done in a good intention. But the court said, it would save considerable time and expense to the patient or relieve the patient from pain and suffering in future are not grounds of defense. So people should not argue with me because the court said they are not grounds of defense. So the only exception the court allows is only life-saving surgeries. If there is an immediate threat to life and it is very difficult to awaken the patient and get a consent, we can operate upon the patient. So the court allowed a common consent for diagnostic and operative procedure at the same time. At the same time, same way, surgery, follow-up surgery, we can take a consent. Consent is not required in medical emergencies because according to law, here the medical considerations takes over legal consideration. But in notifiable disease like COVID, dengue, cholera, we can inform the higher authorities, the public health authorities, because they are called notifiable diseases where legal considerations takes over medical considerations. Same way for all these areas, no consent is required, we can be open. The implied consent, as I said, if the patient is coming like this, how he can give consent? So we can operate upon immediately without a consent, but once the emergency treatment is no longer required, the doctrine of implied consent does not govern. So once the patient is stable for subsequent surgeries, we have to get consent, no implied consent. Same way in the record keeping is a must where the doctors are not doing it correctly, majority of the areas. The court mentioned in one case, postpartum hemorrhage was mentioned, but oxytocin was not given. Not given in the sense it was not mentioned in the record. So the court used these books as reference and they have found out the doctors is guilty. Same way they have mentioned in PPH, the doctor has not attempted hysterectomy. They have consulted a book. Same way balloon tamponade. What I want to say, the judges and the lawyers are also reading medical textbooks and give judgments. So we have to be very careful. Same way, in an expert witness, the court said expert testimony is the best way for us also. We can have an expert, But in this case, Kishan Rao versus Nikhil Super Speciality Hospital, the expert evidence, the court made it clear that the consumer para can allow the parties, it allows expert evidence, but the court says these questions are to be judged on the facts of each case, and there cannot be a mechanical or straitjacket approach that each and every case must be referred for expert advice. And again, the court said the expert can help to find out the cause of death and he can assist the court, but the judgment is to be delivered with a mixed question of fact and law, and the court is not bound in every case to accept the opinion of the expert witness. So we should know that also. So in this case, Andhra Pradesh case, even though the expert opinion said there is no flaw on the doctor, the National Consumer Dispute Resolution Forum has not accepted that expert finding, and they say there are no reading between 3:30 p.m. to 3:50 p.m. because they are perusing the case sheet. So here the expert opinion was not accepted. So what is the important in medical legal implications? You have to communicate very clearly with the patient and the attenders. You have to document the communication, and then communication of the documentation is to be done. Then documentation of the communication is to be done. Preservation of the documentation. So to escape from medical legal problems, these 5 things you should all know. Then the preoperative infrastructure, in one case, the defibrillator was not available. So the court mentioned, that is Gujarat Consumer Dispute Resolution Forum, the anesthetist should have procured the same as a precaution, or should have brought these facts to the notice of the patient's relative, or could have refused anesthesia without the said machine. So if the infrastructure is not adequate, it cannot be an escape route for the doctors. So here the doctor was punished. Same way, the anticipatory blood loss is to be done by the doctors, and the blood should be available in reasonable quantities. If it is not available, it is a negligence. Then routinely people will ask whether the case sheet is to be given or not. There are differing judgments. So one says no, that is a Pune Medical Foundation case, and Maharashtra Medical Council, it says yes. But now, as the legal parlance stand today, you need not give the case sheet copy, but a discharge summary is a must. Even if the patient is going against medical advice, discharge medical summary is a must. A copy of the case sheet can be produced only in the court. See, these are all about consent, but if the patient refuses, it should be always in a written format. Oral informed refusal is not allowed. So the doctor has to prove that the patient has refused it, or else it is called a battery, just like a transfusion in a Jehovah's Witness. For this informed refusal, the patient, as a fancy, the patient wanted not to use their left arm for injection, but one anesthetist injected thiopentone, and again the patient developed a sore arm. The doctor was held negligent as there was a battery. Same way, if you are going out, if you want to delegate the patients to the juniors, delegation should be done only with the equally qualified person. In a medical college, you cannot leave it to the PGs because PG is to learn, but the law requires this only under supervision. Same way, people are having different opinions about postmortem, because the Gujarat Consumer Dispute Resolution Forum said postmortem is compulsory even if the deceased attenders not willing. But the National Commission said when the cause of death is not in doubt, you need not do postmortem. So if the doctor certifies the cause of death, postmortem is not needed. But if they are in doubt, then postmortem is required. But majority of the times in the preoperative death, postmortem will be advisable. So to avoid litigation, never be angry with the patient. Don't charge too much. Don't insist on fees if you expect a problem. Even if you treat the patient free of cost, that itself will be a problem, because the patient thinks there is some problem. That is the reason why the doctor is not asking for fees. Don't insist on fees. Explain everything without any bias. And if you receive a legal notice and if you appear in the court, never irritate the judge. If you receive a legal notice, again, I want to tell you, never go for out of court settlement, because the doctors are worried about their reputation and they go for out of court judgment. If it happens, the patients will be routinely doing that. What I want to convey, if a doctor has not received any legal notice, he may not be a practicing doctor, or he may be a PhD doctor. Instead of a doctor, he may be a doctorate, because even the court, the Supreme Court has mentioned in one case, the cases against the doctors are increasing day by day, and the right to health is guaranteed under Article 21. So, when it is under Article 21, it is a fundamental right. So, the patient had every opportunity to fight against the doctor who is negligent. So, it says, the court, the polyclinics and the government hospitals should provide treatment to the best of their capacity to all patients. So, never go for out of court settlement. And when selecting the lawyer, it is always good to select a lawyer who knows law. And it is better to have a lawyer who knows medicine also. But it is always the best to have a lawyer who knows the practical management. That is important, because it depends upon the circumstances and it depends upon the person who is deciding the case. So it is always the best to have a lawyer who knows the practical management. And as a nutshell, what I want to convey, to give some information to the doctors, what we have learned from the judgments. The Supreme Court is clearly in favor of the doctors. The Supreme Court is not allowing the frivolous petitions. So the Supreme Court mentioned a surgeon with shaky hands cannot administer the end dose of the medicine to his patient. Why I am quoting these lines? If you are faced with a legal notice and if you are defending your case, these are all the words of the Supreme Court, so it will be accepted everywhere. So we can say a surgeon with shaky hands or a physician cannot administer the end dose of medicine to his patient. Same way, a medical professional holding such a professional degree has a discretion in choosing the line of treatment. That's what I say. If there are two lines of management, if you follow one line, you cannot be charged with negligence just because the alternative treatment is available. You can follow any one line. The court clearly says if more than one alternative line of treatment is available, then he can select any route. In one case, the court said the charges were framed against the doctor, but the prosecution has never claimed that the doctor is unqualified. So if the doctor is unqualified, then that may be negligence. Qualified, but what they said, see, they have resorted to angioplasty instead of following conventional line of conservative management. So as the doctor has performed angioplasty, the court has constituted a committee. So the 3-member committee opined he should have applied a conservative line of treatment and not angioplasty. Even though it is an expert opinion, the court has not accepted that as a criminal negligence, because it clearly said when there are two options available, the doctor can select any one option. It is not negligence. So in another case, the Malhotra versus Kriplani case, the Supreme Court mentioned it is for the defendant, that is a doctor. If suppose a notice is served on us, the defense will be the doctor should say he has exercised an ordinary degree of professional skill. Ordinary degree of professional skill. The fact that the defendant charged with negligence acted in accordance with general and approved practice is enough. So the doctor has to say, I have followed the same principles and the treatment available at that particular point of time, or which is authorized by a medical body, like any associations, like Indian Medical Association or Indian Society of Anesthesiologists or Surgical Association. So it should be like that. So again, in this, the Supreme Court has mentioned indiscriminate prosecution of medical professionals will do no service or good to the society. So this we have to use it as a defense. Indiscriminate prosecution will lead to problem. A medical practitioner faced with the emergency, the court clearly says, a medical practitioner faced with the emergency ordinarily tries to save the patient. That is a routine for any doctor. The court mentions he does not gain anything by acting with negligence. So these are all the words we have to quote. So obviously it will be for the complainant to clearly make out the case of negligence. It is not simply the patient has died. The complainant cannot charge the doctor that he is responsible for it. He has to prove. So in the case of state of Punjab versus Shivram, the court in conducting the sterilization operations. So they said the primary liability cannot be fastened unless the negligence of the doctor is established. Just because a patient undergone sterilization, if the patient conceives, the doctor cannot be held liable for that. It is reiterated in the Supreme Court, and here in the Supreme Court, Justice Lahoti has mentioned, instead of saying sterilization, because the word sterilization is used, the patients and the public are saying, I have undergone sterilization operation. He has dealt at length what is sterilization, what is cutting the tube. So for all gynecologists, obstetricians, they should read that judgment by Justice Lahoti, because he has mentioned, instead of saying sterilization, you just say we are cutting the tube. So instead of saying, we are saying puerperal sterilization, but we are saying transabdominal tubectomy. So he himself in the judgment mentions, why you say puerperal sterilization? You say puerperal tubectomy. Same way transabdominal tubectomy. Instead of saying LS, laparoscopic sterilization, he says, you say laparoscopic tubal occlusion, because you are occluding the tube. So these are all the guidelines he himself has given to help the doctors. Because we use the word sterilization, people are saying we have undergone sterilization operation. So you get a consent that the patient's fallopian tube will be cut. Consent should be for that and not for sterilization. Same way the bolum test, everywhere the bolum test will be frequently used. So all the doctors should know what is the bolum's case, what is Martin F. D'Souza's case. These are all the routine thing. So in the bolum test, actually the bolum was undergoing electroconvulsive therapy. In the electroconvulsive therapy, with restraint, they have applied electroconvulsions, but he developed a fracture. So they say no relaxants were used. So there is a negligence. But at the time, the routine practice was not to use relaxants. So the court ruled, as it is a routine test, routinely they have performed. So we cannot imagine things like advanced treatment, like using a neuromuscular blocker. So that is known as Boehm's test. Even now it is used. Because of this only, the court says average degree of average doctor. Same way, in this Martin F. D'Souza case, the court mentioned, if you want to prosecute a doctor under criminal law, not as a civil law or consumer law, if you want to prosecute a doctor under criminal law, first you should refer the case to a medical body. If the medical body opines there is a prima facie evidence, then only you can proceed under criminal law. Because the court said, if you are proceeding just like that in criminal forum or consumer forum, and at the end, if the doctor wins the case, it will not be known to the public, and the doctor's reputation will be damaged. So they said, you have to refer to a professional body, and then you have to sue the doctor under criminal law. So ultimately, what I want to say, we have to be aware of the medical negligence cases. We need not be afraid of that. We should be aware. This is just like a COVID. We need not be afraid of COVID, but we should take some precautions. Same way, we need not be afraid of the medical negligence, but we should take some precautions. So the carry home message I want to say, the doctors and the snakes are respected by public out of fear. Only by fear, because doctors will be needed everywhere in any emergency. So they are respected by the public out of fear. But whenever public get chance, both would be beaten, both the doctor and the snake. So what we should know, the lawyers and the public are dancing on the shoulders of the doctors. They may harass doctors even for flimsy reasons. So to avoid litigation, what we have to do? Be friendly with them, public and the lawyers. Again, communication, documentation, documentation of the communication, communication of the documentation, and preservation of the documentation. That will avoid litigation. So enjoy life. I thank MedPiper Technologies and JournoMed, and I am happy to answer if any queries are there. Thank you.
Thank you, Doctor. We do have a couple of questions. I'll just start from the first one. So, Ms. Kamakshi Selvam have asked, why is this subject not being included in the medical education curriculum for doctors, nurses, and paramedics? Because law and communication skills are essential for the healthcare cadres, either by the Ministry of Health or Law or Medical Council or university or any responsible stakeholder.
Good. This is a fantastic suggestion, and for his information, communication skills are already taught parallelly in the third year MBBS itself. Communication skills, now soft skills are underway, it will come. And as he mentions, it is a good thing to have these medical legal topics in the subject itself. Unfortunately, even in forensic medicine, it was not taught. Only the toxicology is taught there and postmortem, but it has to be included in that. And I take this suggestion, and whenever an opportunity comes to me, I assure that it will be included in the medical curriculum. That is a good suggestion. I appreciate Kamachi Selva.
Doctor, am I audible?
Yes, yes.
Yeah. So for a doctor or a nurse, if they have to approach any of the person in a hospital in case some sort of complications are been happening in terms of patient care, so who will be the first person they need to discuss the issue?
That is, you are asking about in-hospital consultation.
Yes,
In-hospital. In-hospital. I think then I will answer, because the question is not clear whether it is in hospital or outside the hospital. The person delegate wants to know that. But I will tell you, see, it differs from hospital to hospital. If it is a corporate hospital or if it is a government hospital where it has an institution set up, they have to consult the top hierarchy, that is the medical superintendent. So the same way, if a nurse through nursing superintendent, she will consult the medical superintendent, she will inform the medical superintendent. This is a established institution. In a private hospital, the nurses or the doctors have to contact the hospital owner. Sometimes the hospital owner and the doctor will be the same person. So he himself takes over the problem. For this is in-house communication. For outside communication, the person who is in charge of the hospital, he has to communicate. Like first thing will be communicating to the police. So police can be approached by the patient's attenders or by the doctor himself in case of a problem. When there is a problem, especially inside the hospital, if a death occurs, mostly it will create a big problem, and the doctor can easily assess that it is going to happen like that. At that time, the doctor in charge can inform the police beforehand, and he can ask for protection. Then you can break the news. So breaking the bad news itself is a very big topic that comes under communication. So the thing is, the top brass has to act, not the lower level. So in a hospital, government hospital, it could be RMO or medical superintendent. In a private hospital, the hospital in charge.
Thank you, doctor. The next question is, what are the different types of medico-legal issues a doctor should be aware of?
This is a nice question, because mostly the consumer cases which we have seen, mostly it revolves around 16 cases, 16 factors. Most of the time it is charged like this, whether it is right or wrong, routinely. Routinely, what they blame: one, the doctor was not available at the time of need. These are all the routine complaints. Then the doctor charged too much. Number three, because of non-payment of the dues, the dead body was not given to the relatives. Number four, the hospital is not having adequate infrastructure. Number five, untimely referral has been done. Then operation theater is not having adequate facility. Then operation what not done with the due care. Another point, the operation was not done as per the schedule. Then operation theater was not available. These are all the common complaints I have seen in the consumer court cases. Mostly, whether the doctor was there or not, they say the doctor is not available. But for these things now, the Supreme Court has given a judgment recently. That is a good judgment. It says the doctor cannot be expected to sit by the side of the patient. That he has mentioned. Another one, even though the theater is not available, because in one case, two surgeries were happening in two theaters in that particular hospital. So once till the surgery is over, they were waiting for this patient's surgery, and some 3 hours later, he was taken to the theater. That is once the theater is available. Then they said, see, this is a problem. They have operated upon 3 hours lately, so problem happened. So the court said these arguments are not acceptable. This can happen, which is beyond the human capability. Same way, in one area, the Doppler ultrasound machine has gone out of order, and because of that, they have done it the next day. But because of the gangrene, the patient has gone for amputation. So at that time also the court said, see, just because a machine is found out of order, the doctor is not held liable for that. But routinely, these charges will be framed. So we have to be prepared. That is the reason I say you read the Supreme Court judgments. The court has given some clear-cut guidelines. It can be used as a defense.
Thank you, doctor. The next question would be, who owns the case sheet? Insurance companies ask for case sheet. Should we give original or copy?
See, at no point of time, case sheet is to be given originally. No way. Only the court and the police can ask for original case sheet, and it is compulsory that we have to produce the original case sheet only in the court. No one can demand a original case sheet. Everyone can demand the discharge summary, but what we have to say, the discharge summary is to be given to the patient, and we have to get it signed in the case sheet. So again, the insurance company, if it wants a discharge summary, every time we need not give. It is according to you. If you want to help, you can give because it is a discharge summary. If you don't want to take that job, then you can say it is already given to the patient. You can get it from the patient. So original case sheet is to be given only to the court. That is a must. Number two, as situation demands, the police can demand, but original case sheet need not be given even to the police. You can give a Xerox at the time if you wish. Even you can refuse. Legally, the entire case sheet, either Xerox or original, it should be produced only in the court. Original only for court.
Thank you, doctor. Next question, is there any upper limit for professional charges? What all facilities to be there in a hospital to do a surgery? Recently, it was ruled by court that there was no ICU to do hysterectomy.
No, actually, there is no cap on the upper fees. At the same time, I want to tell there is no cap on the compensation also. So the court sometimes it awards 1 crore, 50 lakhs, just like that. Same, it is a professional fees. Court itself mentioned there is no cap on the professional charges. You can charge whatever is required. See, a court will not demand to perform a hysterectomy and ICU is necessary. I presume what could have happened, some problem would have occurred in that particular hospital, and they should have transferred the patient to some other area, stating that this is not available. At that particular point of time only, this sort of a problem arises. See, ICU means it is not a labeled room with ICU. you should have the facilities. That is, a backup ventilator is a must. Now, the court has made it clearly every hospital should have a backup generator and a backup ventilator. These are all the compulsory things. The court will not say the ICU is necessary to perform a surgery, but medically, the doctors have a responsibility that whenever they want to do any surgical procedure, definitely the backup should be there. So medically and ethically, it is needed. The court intervenes only if there is a problem, and when the problem could not be tackled, then only it will come openly. Before that, if a surgery, if you are operating in a room without any facility, as long as things go well, it will not come to the notice. But once a problem occurs, then public will expose everything. So there is no cap. Medically, you are bound to have a reasonable resources to manage the cases. If you want to operate medically, an ICU is necessary.
Thank you, doctor. Medical negligence by non-medical staffs.
Medical, yeah, this is respondent superior. If the patient, if the worker is working in the hospital, non-medical worker, then the liability is on the hospital only. Who is the owner? Who is the employer? Correctly, word will be who is the employer. That is the question. It is called a respondent superior because he is employed by the hospital authorities. So they have to pay the compensation. One, Dr. Venkatagiri, ISA National President, has asked a question. When court awards compensation as per patient's income, can we charge a patient as per his income? Yes, even without considering his income, you can charge anything, because there is no cap on the professional fees. You can charge anything. It need not be related to the patient's income, but compensation will be related to the patient income because they are having multiplying factors. So it is for compensation, it is okay. For charging, you can charge anything.
Thank you, doctor. One more question in the Q&A from Kamakshi Selvam. Why the complaint is not supposed to make a primary complaint to the head of medical institutions before seeking legal remedy?
That is right. See, that is the whims and fancies of the petitioner, that a complainant, he is at a will, because what he thinks, see, imagine if we were non-medical, what we feel, if you represent to the hospital, then definitely the hospital authorities will shield the doctor. That is the perception. So we cannot ask him not to go to the court and he has to approach this. He is at liberty to go anywhere. Definitely he'll go to the court only, then only he can harass the doctor, and naturally natural remedy will be only in the court. So we cannot ask the complainant to go to the only hospital authority. It's not possible.
Thank you, doctor. I think someone has responded. At least in government medical institutions, we have respondent superior as the government or the medical administrations. I think she have.
Repeat.
At least in government medical institutions, we have respondent superior as the government or the medical administration.
Yes. See, actually what happens in government, whatever problem happens, if it is done in consumer council, if the patient approaches consumer council, the notice will be served on the hospital authority only, either the medical superintendent or the higher ups. But what happens, see, as they are not concerned directly with the case, they will forward the complaint to the concerned doctor and they will get a reply. So necessarily, as he said, as a respondent superior only will file the case, and through government pleader, the respondent superior only will approach the court. If there is a compensation, the government will pay the compensation, but the government is at its liberty to find out whether it is as per as per the established treatment, the doctor has performed the treatment or not. So now there is no problem in the government sector because they are having insurance for that, just like a corpus fund. So in government, respondent superior is only filing the defending the cases.
Thank you, Doctor. I think we have answered all the questions requested by the attendees. Should we wait for a few minutes for other questions, or can we wind up?
I don't mind because the idea is that is the reason why I want to cut short the lecture by 40, because see, people will be having queries because they are at their anxiety, they have a lot of questions. So that is the reason why purposely we have done it like that. I don't mind waiting. Or you can
have
initiate
mentioned
any question.
about anesthesia and the medico-legal complications aspects, right?
Which one?
Anesthesiologist and the medico-legal complications. So
Yes.
can you just brief with 2-3 points, like what an anesthesiologist should be aware of, what a common doctor should be aware of, even a dentist or a cardiologist, a basic 2-3 points that they have to remember all the time.
No,
in
the
their
only
daily
thing
life.
is one case it is to avoid medical problem, legal problems. One anesthetist for one patient, that should be there. Yeah, anesthetist should not anesthetize simultaneously 3 or 4 cases. Then he should be available till the surgery is over. He should be available till the surgery is over. And nowadays, multi-parameter monitors are available. So the patient's vital parameters should be monitored at frequent intervals. That is the reason in Andhra Pradesh, the Consumer Disputes Redressal Forum, it has mentioned that the case sheet is not having records from 3:30 to 3:50 p.m. It is only 20 minutes. The doctor will say, all along he might have been working, but he might have failed to record it in the case sheet. But for the court, only case sheet is a must. So same way, for anesthetic also, the recording is a must. So every 5 minutes, basically what I think, every 5 minutes, that is ideal. So if it is very difficult to write, all the multi-parameter monitors will have a printer. So they can take a printout and they can fix it to the thing. Previously, people used to measure it as a chart. Now everything is available digitally. So you be by the side of the patient, take a printout and attach. That is the best thing. And always sign the anesthesia technique and the informed consent should be signed both by the anesthetist and by the patient.
Thank you, Doctor. So can we wind up the session, Doctor?
Sure.
Yes. So thank you everyone for joining us today for an important awareness session on the basic medico-legal complications. Okay, Doctor, we have one more question. Can we take it up?
Yes, yes.
Yeah. So what a medical student mainly CRRI knows
Yeah,
about?
CRRA means house surgeon. I got the
Outside.
point. What a medical student. See, actually, what I want to say, CRRA is house surgeon. See, when the doctors, established doctors, are not even aware of these consumer prospects, I don't expect a CRRA to know everything about that awareness. As that Mr. Kamakshi has pointed out, if it is taught in the undergraduate area, undergraduate curriculum, then the CRRA will be aware of that. But probably why he would have asked, now in the government hospitals, the CRRAs will be in duty in casualty, postgraduates will be at duty in casualty. They would have been manhandled by the furious attenders. That might have been a problem. But see, as a CRRA, pathetically, they cannot do anything on their own. Through their chief, through the hospital superintendent, they will go. So, but the CRRA, by reading so many things, I want everyone to learn from other people's experience instead of experiencing directly. So now itself, when they have time, CRRA period, they will be preparing for NEET. At the same time, side by side, as a extracurricular activity, they have to read the judgments.
Thank you, Doctor. So officially, we are winding up the session on medico-legal complications in India. Thank you everyone for joining us today on a Saturday evening, 5 o'clock. And I wish to thank our beloved speaker for the day, Dr. Meenakshi Sundaram sir, for giving a total brief about what all the legal aspects has to be followed, understood, and how the medical colleges also can implement accordingly. Thank you, doctor. Thank you for this opportunity.
Thank you, thank you. I am available. I am available at email DRAL Meenakshi. So if any doctor is having a problem, they can just mail me. It is DRAL. My name it is DRAL Meenakshi without any gap or full stop at gmail.com. So if they drop a mail, if they are getting into a problem, I will help. It is only free of cost.
Thank you, doctor.